Now, as set forth in my previous letter back in November, it would encroach upon the separation of powers. Okay, that's fine. You don't want to come testify? You know what we do when we have a problem with a judge? We impeach them! They identify a subject's account only by a signifier, which is a phone number. Okay, so now Boasberg is trying to distance himself. He's like, I just called like a phone number came across. I don't know who it's for. It's like, that's Jim Jordan's phone? Holy crap. That's Lindsey Graham's phone? He's like, it's just the number. I couldn't tell the difference. So Comey is being prosecuted for trying to help Hillary Clinton, essentially in lying about it, covering it up. His prosecution gets sent over to a Clinton-appointed judge, and then that judge dismisses the case. Isn't that nice? Jack Smith now gets an official subpoena. There was a back and forth going on between Jim Jordan and the Judiciary Committee and Jack Smith's attorneys, and it continues, but now the Congress has said, we've had enough of this. Jim Jordan said, very simply, Jack Smith subpoenaed. Said he's going to be coming in here for an interview, and if he doesn't, there will be consequences. Maybe after a couple of other letters, but hopefully then we get a referral over to the DOJ for contempt of Congress, and Jack Smith can enjoy 4 months in prison just like Bannon and Navarro did. So Jordan sent this one out. We've also got Boasberg, who's getting ornery. We also know that the Comey prosecution might pick back up, but in a different way than we thought. But here is the latest from Jim Jordan. He said, all right, Jack Smith, you punk. The Committee on the Judiciary is continuing to conduct oversight of the operations of the special counsel that you led, specifically your team's prosecutions of President Trump and his co-defendants. Now, due to your service as special counsel, the committee believes that you possess information that is vital to its oversight of this matter. So based upon communications with your counsel, your lawyer, Jack, we understand that you are available to testify at a deposition on December 17, 2025. And so, accordingly, please find enclosed a testimonial subpoena to get your booty down here at 10 a.m. on 12/17, just days before Christmas there, Jack. And a document subpoena. Give us the materials as well. Bring them in here with you in a briefcase or whatever, and we'll look at them. Thank you for your prompt attention to this matter. Sincerely, your friend, Jim Jordan, over at Judiciary. So that's nice. And we got a response from Jack Smith's attorneys. His lawyer called Peter Koski, Haley Fuchs, who's a reporter at Politico, shared this one. Says, here's this from Peter Koski, attorney for Jack Smith. He writes, nearly 6 weeks ago, Jack offered to voluntarily appear. We don't need a subpoena. Before the House Judiciary Committee in an open hearing to answer any questions lawmakers have about his investigation into Trump's alleged efforts to unlawfully overturn the election results and retention of classified documents. We are disappointed that offer was rejected and that the American people will be denied the opportunity to hear directly from Jack on these topics. Jack looks forward to meeting with the committee later this month to discuss his work and clarify the various misconceptions about his investigation. Yeah, we're looking forward to that too there, Jack. We got a lot of questions for you there, bucko. Hopefully you can get those answered. So he's waking up to a subpoena. Jeb Boasberg, this judge, is rejecting the offer from Congress to come in and explain himself. And of course, he was always going to. He's a federal judge. And here is what he sent back into the Honorable Chuck Grassley, great senator from Iowa. He got his hands on this one, sending December 1st from the Administrative Office of the United States Courts. They say, all right, Grassley, we know you want to talk to Judge Jeb, who was spying on Republicans and more, but here's our response to you. All right, Chuck, your letter from November 20th, it inquires about Jeb, Judge Boasberg, decision-making and his process about the issuance of non-disclosure orders, aka NDOs, in particular matters, and it's been referred to me. So you sent a letter to the judge. He's like, I can't talk about this. Administration, handle this for me. Now, as set forth in my previous letter back in November, it would encroach upon the separation of powers. Okay, that's fine. You don't want to come testify? You know what we do when we have a problem with a judge? We impeach them! So if you don't want to come talk, then the legislative check on the judiciary is impeachment, okay? So hopefully they're waking up to that in Congress. And it would also encroach upon the independence of the judiciary for judges to be required to explain their deliberative process in reaching judicial decisions. And moreover, the matters about which your letter inquires, they're also under seal because Judge Boasberg sealed them. So while honoring these principles, I write to provide some information to help the committee better understand what happened when Judge Boasberg was issuing these non-disclosure orders as Jack Smith was spying on Republicans, saying, all right, in the United States District Court in DC, where Boasberg is on the bench, the Department of Justice has been authorized to file certain categories of sealed investigative applications, proposed orders, and related documents electronically. Okay, so he's like, all right, listen, Boasberg had nothing to do with this. Go be mad at Jack. An application for an NDO, a non-disclosure order, under the law, which would prohibit a service provider from disclosing information about the subpoena, is also filed electronically. Okay, so like, Boasberg's not even talking to anybody. It's like an email came in. The DOJ typically requests that such applications and all related filings be docketed under seal, and these are normally granted. Okay, so it comes in, boom, it's sealed immediately. The district court also dockets non-disclosure orders and related orders using its SC case type. So when it comes in, we mark it down. It's an email, classified, drop down here, SC. NDO applications and orders remain under seal until a request for unsealing is made and granted. So as soon as it comes in, everything is sealed. Nobody's seeing anything. Now, applications for NDOs typically do not attach to the related subpoena. Okay, so two separate processes. Rather, they identify a subject's account only by a signifier, which is a phone number. Okay, so now Boasberg is trying to distance himself. He's like, I just called like a phone number came across. I don't know who it's for. It's like, that's Jim Jordan's phone? Holy crap. That's Lindsey Graham's phone? He's like, it's just a number. I couldn't tell the difference. So as a result, NDO applications would not reveal whether a particular phone number belonged to a member of Congress. And Jack knows all this, right? So Jack is like, no, they'll never tell him. They'll never know. Well, will we even have to explain ourselves? No, it's just a phone number. The judge will never know. And we're the DOJ. They just rubber stamp everything we do anyway, so who cares? So in addition, subpoenas, as you know, are issued by the United States without approval or sign off by any judge, right? So the DOJ, for certain things, can just go in and get subpoenas. So what happens is they go get a subpoena. They're going to execute that subpoena. The non-disclosure order, which is signed off on by the judge, only references a number, and the subpoena is already valid. So the judge presumably still should have gotten some information about that phone number. Like, well, why, Jack, do you not want me to tell this number about the fact that you're spying on them? What evidence do you have? Can you present that to me? Or did Judge Boasberg just say, yep, signed for what? Well, Your Honor, flight risk. Okay, great. Flight risk. Okay, great. Flight risk. Again, ongoing investigation. Judge says, okay, great, right? Is it something like that? Now, without disclosing what is contained in the sealed NDO matters that we're asking about, there are public documents outlining NDO practices in place at the time, including other reports. So here's how the process works. Okay, so what did Judge Boasberg even know? The OIG report documented the process by which the DOJ sought NDOs, the non-disclosure orders, in prior matters involving compulsory process records for Congress. And they've already explained how we do it in this document. The report said that department policy at the time did not require including information in non-disclosure applications about whose record are at issue. So then Jack, okay, they're just dishonest too. Like, well, the rules say we can just get an NDO. We don't even have to tell you why we want the NDO. And the DOJ policy in effect at that time did not require the NDOs filed with the courts to reference the fact that they were for members of Congress. And I'm pretty sure, if I remember correctly, that Lisa Monaco changed those rules after the fact. Okay, Jack Smith came, found a loophole, went, got these records, judge signed off on the NDOs. Then after that, the DOJ went back, they changed the rules. They said, if you're going to spy on Congress, we got to change this. But he had already gotten what he needed. Now, as a result, the NDO applications filed did not reference the fact that these were for Congress people or staffers. After reviewing a draft of the OIG report or records in September, it said, yeah, they explain it, okay? After this, the department revised it, okay? They got all the records, then they changed the rules. In cases where an NDO would delay notice to a member of Congress, and this revision postdates the applications discussed in your inquiry, okay? So the DOJ had a loophole, Jack Smith exploited it, DOJ closed the loophole. Lisa Monaco. Now, the OIG report further determined that department policy permits prosecutors to make boilerplate statements in applications, just as I speculated. Yeah, it's a flight risk. So he got 40 NDOs, and he relied on general assertions about the need for it, right? Well, you know, it's an ongoing investigation. Boasberg's like, great, no problem. Here you go, Jack. And by the way, Boasberg knows what he's working on. The committee report also says that they considered the use of compulsory process for members of Congress, and we should have meaningful judicial review for this, but none of this was enacted into law. Okay, so basically the lawyer for the judge is saying he followed the rules. Jack is the problem. Jack came in, didn't tell us who these were for, didn't need to tell us who these were for. Boasberg knew what Jack was working on, so he's probably like, I don't know exactly what you're getting here, but you got it. Go have fun. Go hog wild. It's like, don't tell me, and it, you know, what I don't know won't hurt me. It's like kind of like, no, your parents go on vacation, you're like, you just have a house party, but as long as you clean it up and everybody's gone and they never know, then you can get away with it, you know? So that was kind of like Judge Boasberg and Jack Smith. He's like, all right, Jack, I'm going to go away for the weekend. Don't have any parties in here. And Jack went hog wild. He had everybody over. It's like a Diddy party. I hope the information provided is useful, says Robert Conrad. Robert, if I may be of further assistance to you, please let us know. Sent over, also copied to Dick Durbin over in the Senate. So that's from Judge Jeb. Looks like he's not going to be showing up, and he's blaming Jack Smith. He says, I don't know anything about anything. These came across my desk. I just saw a phone number. There was blanket statements in there about, well, it's a flight risk. He might destroy evidence, or he might undermine an ongoing investigation. And Judge, yeah, Sure. How many? Just 40? You sure? Don't need any more of those? Come in one after another, just signing them like clockwork. So we also see that there's going to be more developments in the Comey prosecution. So now we've got Jack, we've got Jeb, we've got Comey, and the cases were dismissed in the Eastern District of Virginia. Lindsay Halligan was the prosecutor on that one, and we've been waiting to see what's coming next. There's only so much time for appeals and other options, and been gauging whether or not they will be appealing this. And when we were originally reading the dismissal order, we saw that there was another angle here whereby I think one strategy would be you could just appoint a special attorney, not a special counsel, which requires a cobbling together of different laws in order to create that position, but a special attorney. And what if you don't make that Halligan? You just go find somebody else and you just impanel a new grand jury and you make the special attorney prosecute the case, which I think is a lot more legally sound for the time being. And that might be the direction they're going. NBC says that they're weighing charges against Comey, but not with Lindsay Halligan. So slotting her out, slotting somebody back in. More than a week after the cases were dumped, the DOJ is now trying to figure out what to do. The Justice Department is considering taking the step without legal complications that were caused by Halligan's unlawfulness, which is obviously ridiculous. Now, they said back in November, Pam Bondi came out and they said, we're going to seek an immediate appeal of this. And we all went, okay, well, where is it? And we didn't see it. So then a source familiar with the deliberation said yesterday, the department is considering seeking new, untainted indictments instead of pursuing the appeals. Now, I still think that the issue needs to be appealed because we need to decide whether or not the executive branch ultimately can appoint their U.S. attorneys or whether federal judges can. And I think that they'll be successful on that issue. But there is another option. Former prosecutors and legal experts said that bringing fresh cases might be the clearer path, even if the Justice Department persuades, and I don't think that they're going to get a U.S. attorney in office, Senate approved within the 6 months savings statute, but a special attorney just appointed immediately may be able to do it. U.S. District Judge Cameron Curie said that there was a defective appointment. I think it was a Clinton judge who said that, yeah, it was a Clinton judge. So Comey is being prosecuted for trying to help Hillary Clinton, essentially, and lying about it, covering it up. His prosecution gets sent over to a Clinton appointed judge, and then that judge dismisses the case. Isn't that nice? So Trump, of course, fired Comey, and now he's writing books and taking long walks on the seashell down by the seashore. And you can see that they're talking about this even over on CNN. Here's a little sting courtesy of them.
This morning, sources telling CNN prosecutors will likely present new indictments against former FBI Director James Comey and New York Attorney General Letitia James to a grand jury. According to people familiar with the situation inside the Justice Department, it is expected to happen quickly, perhaps within a week. The court tossed out both the Comey and James cases. The judge found interim U.S. Attorney Lindsay Halligan did not have the legal authority of a prosecutor when the two were indicted.
Yeah, so we'll see what happens next with the DOJ. But Jack Smith getting subpoenaed, and we also see, sounds like he'll be there to testify. So whatever comes next of that, we'll see, and we'll keep our eye out for new indictments for Comey and Letitia as soon as the DOJ figures out what they're doing. But we'll be here to cover it. Thank you for subscribing and joining as we do.